A very warm good evening, ladies and gentlemen. Good evening, viewers. I'm Matthias Aufiku, news editor of the Namibian Sun newspaper. Welcome to another exciting edition of the Evening Review Show. Before we get into the business of the night, let's just go for a short break and then come and hit right straight into the business. Well, tonight we speak legal matters, justice, court matters. We are joined in studio by Mr. Olsen Kahiriri, a legal consultant. Good evening and welcome, sir.
Thanks for having me.
Yeah? No, thanks for coming through. I saw you in court earlier this morning during the bail application, the judgment delivery of the activists, Michael Amshelelo and Dimulukeni Noyoma, where their bail was denied by the court. What did you make of the judgment?
Yeah, according to the magistrate who was dealing with the case, who dismissed the case, he looked at certain elements of law that he was phrasing to. He looked seriously on the aspect of the challenge of administrative justice, whereby he said the prosecutor was relying that releasing the two activists was against the administrative of justice. They didn't say much in the aspect of their arguments in terms of how it would not be in the interest of administration of justice. And I understand if you want to rely on the administration of justice, is when the victim, the perpetrator, the accused, might run away from answering to the allegations that are leveled against them. But that was not the argument of the state. On the other hand, the activist representative, in the name of Amomo and Mata, their arguments was in the aspect that they see the two accused being put in jail on a basis of discrimination because they were 8 and the other 6 were released on bail, and their bail was not allowed on the basis that...
You mean they were released on warning?
On warnings. And that clearly tells you that the case that they are facing was not that serious, because is it the 2 that are having serious allegations and the 6 were not having serious allegations, or and all these things. So the case, just to go straight forward to the case itself, the case was dismissed. The magistrate in question made it very clear that he do not see that the state ought to prove whether indeed that the state has a strong case, as long as the state opposes the bail application. And I tend to also disagree with the prosecutor on that aspect, on the basis that he was also, according to his own arguments, he said one should not run away from the constitutional elements of the accused, both of them, on the basis that they have the right to a fair trial. They are not found innocent up until proven guilty. When you look at his arguments at the end, when he came to dismiss the case, he was arguing that indeed he does not see that the accused would succeed in the case that they have, because the state has a strong case against them. And one funny narrative that he has made, where he relied on dismissing the case, was the one where he said the other accused who went on bail, the court does not have records of how these other accused are released on bail. But you have people testifying that these people are released on bail. And he was relying on such hearsay evidence the whole time. And he was very selective when he had to rely on hearsay evidence when the accused employee and the accused and their representative were relying on the advantage that was given to the other. I'm seeing a possibility of an appeal, because this has a lot of gray areas that has potential to see the light in the High Court. So I don't know what the legal team of the two accused citizens has decided, but I see a lot of gray areas in terms of what I've seen, in terms of the arguments that was put and the grounds that indeed they were denied bail. Because if you look at these, I find funny. That's why I'm laughing. The magistrate was saying he sees these two accused having other cases that they must answer to, even though they are not similar offenses. He sees them having potential to go and commit others. But yet he relies on the aspect where he says these accused, in terms of the constitution of the country, are not guilty until proven guilty in a competent court. So and you are relying on assumptions of allegations that has not seen the test of trial in a court of law.
Is this a common practice in law? Maybe you can enlighten us on that.
In law, when you put someone's criminal record at the test, you must align it. If you want to rely on it, you must align it with the current allegations that this or charges that this person is facing. And totally, the others, the other charges of the previous cases that these two accused are facing are different from the ones that they are currently facing in this court today.
Are you saying those charges should not be considered at all?
You can consider them on the elements that there's bail conditions attached to it and all these things. That's as far as you can go, and their compliance to these bail conditions and things like that. But if the allegations are not the same, you can't say that here you have been accused of stealing maize meal, but here you are facing a case of homicide. It's two different cases. They are not similar. So you can't say that there's a possibility of you being found guilty, because you do not know. You do also not know as a magistrate what will happen in that case. So you leave it as a gray area. And to me, the state, without them, you see, it's a narrative that we should challenge. And that's why, as a person in a legal fraternity, you would want to have this accused taking this case up until the High Court and Supreme Court, if their answers are not at the High Court, because we want to see what the court says in terms of because we must understand this is what we call in law the locus classicus case. This will be the first of its kind after independence. And inciting public violence, it's a new case in Namibian scene. And if it ends at the level of a magistrate, would continue ending there, because magistrate cases, we can't reference to them. Now, High Court arguments would broaden the scope and will be able to give us more narratives in the legal space in order to deal with cases of that magnitude, because what we are seeing as a country, the dissatisfactions of the Namibian people has reached the boiling point. And we would see a lot of such similar cases coming to the fore. And it would be fair that we have an interpretation in terms of the Namibian constitution at the courts, in terms of what most politicians, activists would be engaging themselves into from here to 2024. Because we see a different political space where which is similar to the one before independence. And I always say the law is there for and to protect the Namibian citizens. And if it does not protect or is not in the interest of the Namibian people, what one should do is face the law. It will have serious repercussions of having some people injured, like those who are in jail.
Yeah.
But at the end of the day, once you face the law, you would sometimes make or force or compel the lawmakers to amend, or the courts to interpret it for it to be amended.
Yeah. Of course, this is a very emotionally, you could say emotionally charged case because of the wide impact it has on society as a whole. So from the court's point of view, because obviously there are those, you saw the disappointment of the crowd in front of the court earlier today. But then where do you draw that line between implementing the law and ensuring the law takes its course, and also at the same time meeting the needs of those who are affected by this law?
No, but you must also understand, now I'm speaking with a legal head, you must understand that criminal charges are very serious in nature. And time and again, I do not say that I subscribe to the notions of separations of power, which is enshrined in our constitution. In practice, in writing, it is there's separation of power, but in practical terms, I do not see that. And sometimes there's a person with dark specs. When you see them in courts, when you see them entering offices, these are people that are used to influence decision from the executive aspect into judicial proceedings and things like that.
Are these perceptions or things that are happening?
One would say it's perception because it's not yet proven in any competent court of law. But we are not blind. We know where we come from as a country. We had our people who were jailed. This is normal when it comes to transformations of power, because we are touching, if you look at the accused, they are touching at challenging the powers of those running this country. And when you push against those who are in power, they will push back. And you won't see them, but they will use the resources of the country to make sure that indeed you remain in custody. And one important aspect, the challenge to the Namibian democracy and the state itself and its administration is the challenge that when you do not deal with these two activists, they are also having a challenge of there will be more unrest coming, because you cannot criminally put this person in jail. He would use his powers to get out of jail. But let's look at all the bail applications we have in the country. There are certain people who are having serious criminal charges of homicide, rape. People who rape were even out because they are linked to the state and all these things. We have cases of that magnitude.
But we understand that at law school, you guys are taught that each case is dealt with by its own merits. When does that apply?
But the merits of this case, as I saw it, was that with the moment you release the 6, you have to put the field at the same level. You can't discriminate against the others. Because discrimination is one of the pillars of the Namibian constitution. The Bill of Rights speaks of discrimination, because discrimination is what we inherited in a apartheid era. And it's one of the elements that we should not practice. And an administrative body, in terms of Article 18 of the Namibian constitutions, must take a fair and reasonable decision. And it can't be fair and reasonable to give bail to 6 people and the other 2 must remain in custody because at the end of the day, they are all facing the same charges.
Yeah.
It's just that, unfortunately, one of the accused in the 6 that got bail is a member of parliament.
Yeah.
So what are we saying? Certain creatures in this country has more status than others. But in court, it can't be like that.
Yeah.
The Constitution is very clear. Everybody should be treated fairly and squarely like the others.
Yeah.
And that's why I see this one having a potential for an appeal and going forth, because Namibian courts, we know we don't trust them. It's a very long process. It's a long process. No, I'm not saying it because...
let me just break you there. Just hold your thoughts. We'll go for a short break and we'll be back to continue that conversation regarding the trust from the public side towards the judiciary. Just gather your thoughts around that. To our viewers, we'll just go for a short break and we'll be back soon to continue this conversation.
If love would come my way, sitting waiting for my life to start. Oh yeah, I couldn't help but wonder if I'd see a brighter day, that I would find some peace of mind, and love would fill my heart. Thanks to you, I got a reason every day to keep believing I can do.
Well, let me welcome our viewers back from that short break. Mr. Kahiriri, let's continue the conversation. You were about to touch on the element of trust as far as the judiciary is concerned and the work it does. Of course, the judiciary itself has over the years prided itself with being fair and balanced and objective as far as dealing with judicial matters is concerned. What say you on that?
I went to law school, so I can't be told by people just... It's a narrative that is there. The legal system globally is for the rich. It's not for the poor. For you to appear in a court, you must be represented by a lawyer that you can't afford, a lawyer that probably must go through the government to assist you to have a lawyer. And most of those lawyers through the legal assistance center is the legal aid. They also do not do a proper job. So the law itself is not designed for poor people. The law is designed to protect the rich. Why am I saying that? Look at how we have designed our Bill of Rights. Before the independence, all the resources and properties that we were told we can't have as ours were in the hands of those who were in power. And when the Constitution was enshrined, is to protect the properties and resources of those people. It's the very same people that are doing business into this country, whether they come from China, Taiwan, Taiwan, those friends of those that are leading the country. They are more favored than any other citizen of this country. It's high time that we start realizing the reality when it comes to the law. When you take 2 accused in a drink and driving case, an elite and an ordinary Namibian, the elite will go scot-free. So we don't balance and strike it as being equal. For you to access the courts, you have been pushed left, right, center. You do not know how to fill in those documentations and all these things. And you say the criminal justice system in our country is, or the legal system in our country is fair to everyone. I don't buy that myth, because I worked on a day-to-day basis with labor cases. All 99% of the labor cases that you find at the Labor Commission's office is unfair dismissal. And who should get a remedy out of that is the public, is the poor people. And how long do we have those cases on a roll? 2 to 3 years. While the legal system that you have crafted should give you an answer in 3 months.
Yeah.
That's why you have one of the useless ministers. Every time they ought to go to retirement, they are put at the Ministry of Labor and all these legal structures for them to be as weak as they are. So I still believe that we can do more when it comes to our legal system, but I still believe that the judges, magistrates, sorry to use it, they are members of the ruling party. Because we appoint these people in quota system, in Namibian employment setup. These people are belonging to the ruling party, and when the ruling party is being challenged, they will be put into places to make sure that they use a thin line to put you outside the society. Because most of the people that speaks for the interest of the society, if you don't shoot them dead, you put them in jail. And that's what we are seeing.
Yeah.
We are trying to run away from the corruptions that we are doing. Look at the statement that was made by Meme Shaningwa. She said it in Oshuambo that what does that? Inciting violence. Was that woman arrested? The Itunga will never do anything. So that's where the problem is. The Itunga is being kept at that portfolio to make sure that when you are trying to ask state resources that are stolen or try to challenge the status quo in a country, the police are being used in the street. And these things has been done for quite a long time now. And how do you say the justice system is fair to the Namibian citizens?
Yeah.
It is not fair. We see complaints of people every day at our offices not having justice in this country.
Just as we wrap up, of course, there's been talks that this case might be political. What is your view on that?
Is it not?
Well, you tell us.
Is it not? Because you see the statements that the accused are facing is political rhetoric that they have been making, that the government is favoring the Chinese businesses. And that's the fact. The relationship between SWAPO and the Chinese Communist Party, it's daylight. And that's what we are seeing being pushed into the courts. And it's high time that the Namibian people wake up and start smelling the coffee.
Yeah.
Because today it will be the two accused, tomorrow it will be you.
Yeah. Lastly, Olsen, before we wrap up, on the judiciary again, of course, there's also this argument to say we only tend to castigate the judicial system when cases, the outcome is not in the favor that we want. What do you say to that?
You see, those who goes into the street and challenge the status quo, they are not happy with the way the laws are applied in their country. And that's why they said the discrimination between NAMRA and vis-a-vis NAMRA's actions against the Namibian citizens vis-a-vis the Chinese. Did we draw up the dichotomy? Did we engage into the differences of how these things are done? It's not the Chinese issue alone. It's the employment setup in this country, the arrogancy, how the president speaks in this country. When you try and ask accountability from these people, the way they react and the way they put police in. You see, when I even went to court, I looked like also a criminal in this country. That's how the police were even treating us, citizens. Because who said so? Those who's in power. And the very same way Nelson Mandela told us, he told the South Africans that if ANC government does what the apartheid system did to you, you must do what we did to the apartheid system to the ANC. And I see it as a turning point in Namibian politics that the ruling party is in trouble. They cannot account to promises they give to the Namibian people. Now they should go and silence those who are the voice of the voiceless. So by putting them in jail and putting fear that whoever stands up and challenge the status quo will be put in jail.
Yeah. Olsen,
Uh,
thank you very much for your time.
Thanks for having me.
Have a good evening. To the viewers, that's all for tonight. Thanks for following the discussions today and have a pleasant evening.